Hello, Brits!
There are serious, therefore, consequences to the way in which he is being held.
Something major just went down in the British legal system involving Tommy Robinson.
In terms of life-threatening illnesses or similar serious deterioration.
In a jaw-dropping turn of events today at the Royal Courts of Justice, one of the UK's top judges led a legal clash that could shift everything. With Lord Justice Edis, Baroness Carr, and Lord Justice Warby present, the pressure in the courtroom was immense. The authorities aren't stepping back. They've demanded total compliance, including the takedown of certain videos from social platforms. And that's where the freedom of speech debate kicks off in full force.
We say that's very significant in this case, because in this case the judge took the sensible step of breaking the penalty down into a punitive element of 14 months less 3 days and a coercive element of 4 months. In other words, it's in the appellant's gift to shorten his own sentence by 4 months, if only he were to do the things that the judge said he should do, remove his post from social media and take other steps to prevent its dissemination.
We're talking about censorship, the right to speak freely, and even the impact on someone's mental well-being, particularly with a recent ADHD diagnosis now being introduced as new, relevant evidence. While traditional news outlets stay silent, Channel 4, BBC, not a word from them. We're here to shed light on what's being swept under the rug. Here's the real question. 25 convicted individuals were released, all while Tommy remains locked up in a maximum security prison. Why? Because he stood firm and refused to pull a documentary that openly questions those in power. Is this what justice looks like, or are we seeing signs of authoritarian control?
Aspects of segregation are likely to be particularly difficult for a person with ADHD.
What caught everyone's eye were Tommy's subtle moves during the hearing hand signals, unspoken cues, and a direct challenge to the officials over the public's right to the truth. Could this be an orchestrated effort to shut down opposing voices using the courts? This video is crucial. Make sure you watch till the end to fully understand what's at stake. Drop a like, share it, and hit the bell icon because there are those who'd prefer you didn't see any of this.
There's obviously a deal of material for us to consider, as well as submissions of law. So we are not...
It should not be lightly taken that Mr. Yaxi Lennon's condition is described as complex post-traumatic stress disorder and that he is not currently in mental crisis. It is clear from Dr. Connolly's report that what tends to happen for Mr. Yaxi Lennon is being held in segregation contains him and his symptoms, but it is on release he demonstrates behaviours which are harmful and indeed raised questions in those immediately close to him as to whether or not he may seek to take his own life. There are serious, therefore, consequences to the way in which he is being held. It is on the point of deterioration that I may turn to the question of extension of time. It is right that the first mention in the prison records of concerns on his part of mental health deterioration is on the 12th of December, but it's not right for my learned friend, for the Solicitor General, to focus on that date. It is clear that there's a further mention on the 27th of December, and that, of course, in terms of our obtaining a report, it had to be seen that what was going on was not transitory, but indeed represented a consistent decline in his health. And this court may observe that it is not unusual, certainly in the criminal courts, for there to be a similar delay to the period we've seen in this, in order to find experts who are able to address these issues. So we say the extension of time arises out of the fact that it took some time for him to cease being able to cope. It took some time to establish that that decline was not transient, and then we had to obtain a report in circumstances where the court knows resources in the mental health facilities are overstretched. The question as to whether ADHD was reasonably discoverable, my learned friend graciously does not seek to resist the adduction into evidence of Dr. Connolly's report in respect of complex post-traumatic stress disorder, but says, well, look, Mr. Yaxley-Lennon has always suffered from ADHD, and therefore, under the usual principles, that can't be adduced as fresh evidence. We say, looking at Dr. Cutland-Green's, as the court observes, detailed letter, she sets out helpfully that Dr. Leahy, psychiatrist, had already seen Mr. Yaxley-Lennon and referred him to her. Neither of those healthcare professionals had seen that he suffered from ADHD. That is, we submit clear evidence that in fact that condition was not immediately obvious and was not discoverable by the application of reasonable diligence. It took, in fact, those with experience of this issue to recognise that that's what he was suffering from. I'm going to avoid, I hope, the bear trap of describing it as solitary confinement. I accept its segregation. Aspects of segregation are likely to be particularly difficult for a person with ADHD due to the need for stimulation, inability to relax, and attentional difficulties. And she goes on to describe how the regime under which he is being held precludes the means by which he can typically regulate his emotions.
Can we see in Dr. Connolly's report an understanding on her part that the appellant was not in solitary confinement?
She sets out, and I think part of the difficulty may have been that the regime changed just before the judicial review proceedings. She does detail the circumstances in which he's being held. And it may be that she misuses the label, but she does have a good understanding of the conditions in which he related to her, that he was being held.
All right, thank you.
This part is crucial. Make sure you watch till the end to fully understand
Approach when sentencing for crime and when sentencing for civil contempt. Here, Lord Justice Coulson refers to the Divisional Court in Booth, which he says also emphasised that the purpose of imposing a sanction for contempt is to punish the breach, ensure compliance with the court orders, and rehabilitate the person in contempt. And the fact of compliance with court orders is then emphasised again in the following paragraph, summarising Couturier and Willoughby. An important aspect of the harm is the breach of the court's order, and an important objective of the sanction is to ensure future compliance with the order in question. We say that's very significant in this case, because in this case the judge took the sensible step of breaking the penalty down into a punitive element of 14 months less 3 days and a coercive element of 4 months. In other words, it's in the appellant's gift to shorten his own sentence by 4 months, if only he were to do the things that the judge said he should do, remove his posts from social media and take other steps to prevent its dissemination. He hasn't done that. It's a striking feature of this appeal that he remains defiantly in breach of Mr. Justice Nicklин's order. That further publications of his film are occurring every time it's viewed. But at the same time, he comes to this court asking for an indulgence, That's what this appeal really boils down to. He's asking the court to take the exceptional step of reducing his sentence on compassionate grounds, even though a review of the sentence discloses nothing wrong or unjust at all, that we say.
That is a strong forensic point. Is it relevant as a matter of principle that the appellant has not purged his contempt, thus achieving his release? I think it will be at the end of this month.
I think it will be the end of next month. We say it is because you're being asked to do something exceptional in all the circumstances, and you have to take into the circumstances not only the mental health deterioration, but also the ability that this appellant has to help himself. So we do say it's relevant to the court's exercise of its discretion in this case.
Here's the final part. Is this justice?
Lastly, if I can read my own writing, in terms of when something may be discoverable and whether his mental health condition should have been brought to the attention of Mr. Justice Johnson, again, if one looks at Dr. Connolly's report, it's evident that he and his family didn't realise that he had ADHD, and I think his mother just regarded it as the way he was, in contradistinction to his siblings. And so to that extent, it may be a bit like a latent issue in other circumstances. One simply doesn't know that one has that problem until a professional sees the symptoms and assists you with that. And so that's why he wasn't able to assist Mr. Justice Johnson as to his condition. Even if an adjournment had been obtained, there's no necessity that the psychiatrist or psychologist who saw him then would have spotted those symptoms. He took a specialist such as Dr. Connolly. My lady, my lords, unless I can assist you further, that is...
Me? Thank you. Well, thank you all, both counsel and those sitting behind them, for their very helpful written and oral submissions this morning. You're going to reserve? Happy to... Yes. There's obviously a deal of material for us to consider, as well as submissions of law. So we are not inclined to deliver a judgment today. We will be reserving our judgment both on the applications for an extension of time and fresh evidence, and also any ensuing substantive decision. We will let counsel know in a normal way how and when we will be handing judgment down. Obviously, we know what the timelines are because we've exchanged dates on that, Mr. Williamson. Are there any other particular matters that you would urge upon us in terms of timing?
Thank you. Would you mind my bag just for a minute, lady?